In this segment, we are going to focus on detention. But first, I wanted to mention a recent decision in a California court that allows appointed attorneys for persons with mental disabilities who are in the detention immigration removal system. This only applies in 3 states, but it's the first inroad into generally not having a right to an attorney throughout the process. But it can be particularly troubling with detention, and so I wanted to speak with Amna about that, about the detention process. And just to give you some background, there are 250 facilities in the United States. There are currently nearly 500,000, or at least the 2011 statistics show 500,000 persons in detention. And in the last decade alone, 3 million persons spent some time in detention. But you have some familiarity with that process.
I do. I have, because my practice area focuses on detention and removal issues, I have a lot of cases that are referrals as a result of previous work that I've done. And here in Atlanta, we have several facilities that are in Georgia. We have the North Georgia Detention Center. We have Stewart County, which is notorious. They have their own immigration court. And
an immigration court in the
jail,
facility.
Yes, in the jail, so they can remove people even more quickly, I like to say. But and we have a third. But the other, besides Stewart, the two that we have in Atlanta, in Georgia, they come through the Atlanta Immigration Court. The one in Stewart County is the one that I find to have more trouble navigating, and that's because it is 3 hours and 3.5 hours maybe from Atlanta, and it's very far away. The judges, I think, in the Stewart County detention facility, save for one, are extremely overzealous. The people in the jail itself do not have access to representation because they're sort of based down there. It's a region of the state where there are not a lot of immigration lawyers, if any, that are, I'm sorry, good at what they do. So you'll find that they're getting, attorneys who just come in and maybe pick up a case, but in many cases they're either poorly represented or they're not represented at all. And because the conditions in Stewart County are just so difficult, many detainees in that facility will end up just signing their deportation just to get out of what they see as very hellacious conditions. Those that are lucky enough to have family members who retain counsel, even at that stage, it's very difficult for counsel to be able to represent them. We are able to do bond hearings for these individuals, and they routinely grant what's called a telephonic appearance. So to save the client the cost and the money, and the attorney the time of having to travel down there, it makes it easier for the client to afford us to represent them.
What are some of the grounds for bond? In other words, if you're in detention and if you are able to get an attorney, what more do you need to try to get a bond posted so that you would be out of detention prior to your immigration court proceeding?
Well, basically, in order in this jurisdiction, and I find and I don't practice in every jurisdiction, but in the ones that I'm going to speak about my experience just in general from the ones I have, I found that the majority of judges will only let people out of detention if they have some form of relief from removal. So for example, if you are asking for a program like cancellation of removal, I would file a bond motion that shows a prima facie eligibility of that program. We don't need to go into the program itself, but just to show that this person qualifies for a form of relief in this particular form. I would show as much as I could to convince the judge that they had a decent, at least, right to argue this case. In addition to that, you have to show that the person is not a flight risk. You have to show that there is somebody who's able to pay their reasonable bond. and you have to show that they are not a danger to the community and they're a person of good moral character. And various judges have various ways of looking at this. Some look at things like DUI and multiple driving without a license convictions as much more harshly than other judges. However, there are certainly criminal grounds to not let people out even if they qualify for relief. So for example, if
mandatory detention.
Well, there's mandatory detention, but there's also discretionary detention based upon a judge feeling that a person just doesn't deserve to be out. So even if it's not an aggravated felony, which triggers mandatory detention, and somebody may have 3 DUIs, for example, a judge may say, you know what, I think this person's a danger to the community. They have 3 consecutive DUIs over the course of 10 years. It's in my discretion. I'm not letting this person out. Now, you have the right to appeal that decision to the Board of Immigration Appeals. But in most cases, what I find, if an individual is facing another 70 days behind bars down in Stewart, and versus being able to get out and litigate their case while being out, some people will give up their form of relief and just say, you know what, I just want to leave. I cannot deal with this anymore. So one of the problems I find with defending people who are in detention is that they oftentimes, if they can't get out on bond, and that is discretionary, it's up to the judge, there's no requirement that someone's let out on bond. It's just that if you can show that someone's worthy of hopefully getting out, then the judge can set a bond, and then if they can pay it, then they can get out. One of the problems is that if they don't get that bond, or if they can't afford the bond, that people oftentimes will give up when faced with the idea of litigating this case while they're in jail. So,
which is very difficult to do at best, and with an attorney.
Right. And the cost associated that for what's probably an indigent client is in many cases out of reach. And so it's a very unfair system for these people.
Well, speaking of cost, let's look at it from the other side. When we talk about immigration reform, one of the issues that comes up is the enormous cost of this system of detention and the removal proceedings and so forth from the government's perspective.
That's right.
So they're spending a lot on detention.
Well, one of my arguments that I make when I am, when I'm in a particularly resistant bond case is that public sort of policy argument. This person, it's going to cost you more to detain this person and this person has U.S. citizen relatives who rely on this person's income, who are facing losing their home or whatever the case is, and weighing the equities here. Or, if there is an issue of discretion and it's on the fence, I'll throw that argument in there. We're facing a situation where this person is going to have to litigate this while in detention at the cost of the government. And is that something you want to do when you look at, this over here? There may be 4 U.S. citizen children who are facing possibly going on public assistance because their breadwinner is in jail, versus if he or she were out, that would not be the case. So, you can make those public policy arguments because you're right. There's a huge cost to detaining individuals, which is why they try to bond people. There is an incentive to bond people out, I think. And there's also a high incentive to get them out, either through an order of removal or something of that nature as well.
The preceding program is copyrighted by Emory University.